Welcome back to the fourth session on our day exploring artificial intelligence and judgment. And we finally come around to what you've all feared, that's the law. I'm Jeremias Adams-Prassl. I'm a professor in the law faculty and research associate at the Institute. And what we are going to explore over the next hour and a half or so is the impact of AI on law. Now, like most areas of human expertise, AI and digitalization more broadly beyond artificial intelligence promise to revolutionize the law. Key elements of litigation, such as, for example, discovery, have already become largely automated. Things lawyers would have done even 10 years ago, today completely automated. And with the advent of GPT-3 and ChatGPT, we've already heard much about today, entrepreneurs are becoming ever more confident about disrupting the law. Earlier this week, some of you might have seen Do Not Pay, a well-funded UK-American law tech startup, posted the following rather startling offer on Twitter. "We will," I quote, "pay any lawyer or person $1 million with an upcoming case in front of the United States Supreme Court to wear AirPods and let our robot lawyer argue the case by repeating exactly what it says." Now, as far as I can work out, a quick perusal of the rules of procedure of the US Supreme Court suggests that electronic devices are entirely banned from their courtroom. So this is probably just a clever marketing ploy. I'm not too worried yet about US Supreme Court litigation. But that is not to say, I think, that the legal profession doesn't face some potentially very serious upheavals and challenges, up to and including the very core of the law, the role of judges and their judgments. So these are the kinds of questions we're hoping to explore with you over the course of the next 90 minutes or so. And I'm really excited we couldn't have a better lineup than our speaker and discussants today. We'll start with Lord Neuberger of Abbotsbury. David actually is a proper scientist. He didn't read law, he read chemistry here at Oxford before he was called to the bar in 1975. He became a High Court judge in 1996, going on to become a Lord Justice of Appeal in 2004. Crucially, in that year, David was also appointed as the judge in charge of IT and modernisation in the court system. He became a law lord in 2007, Master of the Rolls in 2009, and then in 2012, President of the UK Supreme Court. Since his retirement from that position in 2017, he's practiced as an arbitrator and a legal expert from one Essex court. So we're really looking forward to hearing from David about the role of judgment. We'll then have two responses. First, Aislinn Kelly-Lyth, who's a pupil barrister at Blackstone Chambers and a research associate here at the Institute. Aislinn completed her undergraduate degree at Cambridge University and then an LLM at Harvard Law School, going on to become a Queen's Scholar at Middle Temple. From 2020 to 2022, I was very lucky. She was a researcher on my algorithmic management project here in Oxford, but she's now gone on to the dark side into legal practice. Aislinn's work has also been published in leading journals, including both the Oxford Journal of Legal Studies and the Modern Law Review. And then finally, we will hear from Sandy Steele, a colleague from just across the road. Sandy is a professor of law and a fellow at Wadham College. He's also a visiting professor at Notre Dame Law School in London. Sandy's interested in philosophical and doctrinal questions, primarily about private law. He's written mostly about torts and private law theory, but he's also interested in general jurisprudence and has co-authored with Nick McBride a critical guide to the subject, Great Debates in Jurisprudence. So with that, I look forward to hearing from David first, and then hopefully Aislinn and Sandy will kick off our debates.
Good afternoon. It's a great honour, somewhat intimidating to be here, talking about a subject which I meant to know something about, law, and something which I'm not sure I do know very much about, artificial intelligence. Just to set the justice system in its place, it's one of the three limbs of our constitutional system, together with Parliament and the executive. And also, together with a democratic legislature, I suggest the rule of law is one of the two foundation stones of a civilized society. And in a nutshell, the rule of law involves just laws and access for everybody to the law, to see what it is, to legal advice from competent independent lawyers, and access to the courts. And the courts consist, or should consist, of independent, competent judges, administering justice, and making effective decisions, listening to arguments and evidence in open court, and giving reasoned judgments which are publicly available. It's as important that justice is seen to be done as it is that justice is actually done. And this all sounds rather trite, but it's important to bear in mind when we're talking about artificial intelligence judges. Now, before I turn to what I was going to talk about, can I pick up one or two points that have been made during the course of this morning? Because I think they were very interesting points that are worth discussing a little. First of all, Grant LeMond's description of how we're basically reliant on statute law made by Parliament and judicial law made by judges, and his description of it, subject to one small point, was something I entirely agreed with. Basically, Parliament makes the law in statutes, and over the years it has taken over that role more and more. The judge's role is to interpret statutes, and also, where the statutes don't apply in areas like contract and tort, to make the law, to apply the law and to develop it. We are finding ourselves at the moment with statutes which are overcomplicated and unclear. And in the end, the role of the statute is to make general rules because it's of general application, as Grant described, and for the judges then to apply it in individual cases and to develop principles for interpreting it. So far as judges' functions are concerned, they don't only interpret the law, and they don't only apply and develop the law. They also have to resolve many factual disputes. They have to apply exercises in discretion or judgment, balancing factors against each other, and often they have to determine questions of expert evidence. They develop rules. Sometimes the rules are made by Parliament, but they develop rules. For instance, when you're interpreting a contract, you have to decide what the words naturally mean, but you have to decide that in their context and by reference to commercial good sense. And for instance, different judges will vary in the emphasis they give to commercial good sense and the extent to which they're prepared to bend the natural meaning of the words to comply with what they see as commercial good sense. When it comes to assessing witnesses, there are those judges, increasingly few, I hope, and I'm glad to say, who think it's very important to rely on the impression a witness makes when giving his or her evidence. That was a popular view among judges, but is now rapidly falling into desuetude, I'm glad to say. One of the many questions which have to be balanced are certainty against fairness, or certainty against justice. When I was in the Supreme Court, I had colleagues who had differing views, and I had one colleague in particular who was very keen to lay down the law in clear terms on any topic he could, with a view to making the law clear and certain. And there was another one who was at the other extreme, who thought that in the traditional common law way, the law should develop on a case-by-case basis. We reached, on various cases, we reached a certain amount of agreement, on various cases, a certain amount of disagreement. And to give you an example, contracts which contain an illegal element. One of the judges wanted to lay down a highly principled rule that basically if the person seeking to enforce the contract wanted to rely on illegality, on anything involving illegality, then the claim had to fail. The other one took the view that where there is an illegal element, you should consider it generally on a case-by-case basis and build up the law by reference to individual cases. You can't say one view or other view is right. They both have their arguments in favour and against them. And there's a lot to be said for an appellate system where you have an appeal court laying down the rules, but different views applying, sometimes a compromise view arising, as it always has to, for instance, in the European Court of Justice, where they can only issue one judgment, as a result of which sometimes there's a complete mess because they have to accommodate as many views as they can, and therefore the judgment is sometimes, by no means always, internally incoherent, or else doesn't actually answer the question because they couldn't reach enough agreement. Our system has the advantage that each judge can give his or her own judgment, but the problem is that you then have 5 judgments, sometimes, all of which say slightly different things. So that can be said to be equally much a muddle. There are different models for justice. When it comes, of course, to developing the law, I developed the law, you're a maverick, and they are a rule breaker. It's always a question of degree. But braver judges, or more bold judges, who do make mistakes or do develop the law or overdevelop the law, can nonetheless be helpful in the same way as we are all here because DNA goes wrong and makes mistakes, and that's how evolution occurs. And diversity of views is a good thing. The law develops, particularly in difficult areas, by debate, discussion, and individual cases helping build up the law, as I've indicated, in many areas. And to that extent, coming back to what Honora was talking about in terms of what some people call flaws, flaws could be said not to be flaws, but help the law develop. Even when something goes wrong and the Supreme Court, for instance, decides something which ultimately turns out to be wrong, that itself can be useful in helping develop the law on the longer term. It's not much fun for the litigants, but in terms of the future of the law, it's not a bad way to develop. There was mention of corrigibility. In that sense, internal corrigibility is quite a good thing for a judge to be able to administer to himself or herself. You hear arguments during a case, and if you're any good, you will, having had an initial view, because whenever you read papers in a case, you have an initial view, but you should be able to change that view as you listen to the oral argument. That's the point of oral argument. Some of my colleagues, you could almost hear them trying not to change their minds because they didn't want to reconsider. But in fact, it's a good thing to do. I liked having my mind changed, probably too much. But it's how the system works. And of course, with our system in this country, we have an inbuilt corrective in terms of the appeal system. Case can go from the judge to the Court of Appeal, and from the Court of Appeal to the Supreme Court. And that enables a judge to have his or her decision corrected. One of the nice things and not so good things about being in the Supreme Court is that, subject to the case going off to the European Court of Justice, which it could do when I was there, and now going to the Court of Human Rights, you are the last word. Nobody can overturn your decision, subject to one point. And that, of course, is an advantage in that you don't worry about being reversed. But actually knowing that there's a court above you that may be able to reverse you makes you think extra carefully about a case. Of course, in this country, we have the added point that we have parliamentary supremacy. Unlike the United States, we haven't got a court that can overrule the legislature by saying that a particular statute is unconstitutional. So any decision, even if the Supreme Court is plainly right, could be overridden by Parliament. I mentioned that it's of the essence that a judge must give reasons, at least in a civil or family case. If a judge, after hearing a case, gives no reasons for his or her decision, then the decision will almost certainly be reversed and sent back for a fresh hearing by the Court of Appeal. Reasons are accorded great importance. And that's all, of course, because of the fact that the judge is performing a public function, and the judgment is a public document and adds to the law. It's ironic that in criminal cases, which could be said to be the most important cases and that people's liberty is at stake, particularly big cases, go to juries. And the one thing juries can't do is to give their reasons, merely have guilty or not guilty. Which suggests, coming closer to our subject, that from the public perception, given the great importance accorded to maintaining the jury system, that there is particular faith in having human decision-making rather than machine decision-making. Another point that has occurred to me as highlighting the relative importance given to human decision-making rather than machine decision-making is the absence of the use of polygraphs in court. Although, if I read correctly from surfing the internet, polygraphs are said even by the government to be 90%, some say more, some say a little less, reliable in terms of identifying whether somebody is telling the truth or not. Nobody suggests using them in court. A judge who was right 90% of the time about whether a witness was telling the truth or not would be exceptional. Now, it's fair to say that many, and in my view, although views may differ, most people who give evidence which is untrue aren't actually lying. They are either mistaken, been persuaded to change their minds or form a view about something they actually didn't see, or are indulging in wishful thinking. But even so, one would have thought that a polygraph, if it's 90% reliable, would be quite useful where there is a flat contradiction of evidence between two witnesses to see if either was lying. But nobody has seriously suggested their use. It's interesting because, picking up a question put earlier to today, this afternoon, there is, on the other hand, a great belief in science. The post office case was mentioned. And then there was the baby shaking case where a woman was imprisoned for killing, allegedly, her baby on the basis that two of her babies had died. And the statistical evidence was such that it was so improbable the jury convicted. It shows an undue belief in science, or perhaps, if you want to be unkind, a piece of incompetence on the part of the legal profession, that in the post office case, the great majority of the defendants were advised by their team to plead guilty on the basis that the evidence from the computer seemed unanswerable. And similarly, and it was flawed, and similarly, in the baby shaking case, the statistical evidence was actually flawed. The mistake made was to assume that each baby had died was a separate incident and there was no connection between the two. And of course, the argument for the defendant, for the mother, was that they both had some sort of inherited or environmental problem, which meant that there wasn't the coincidence of two separate incidents. But the statistical evidence from somebody who was not really a statistician persuaded everybody, including the jury and the judge. I think we therefore have to be careful about our belief in science, but it does seem to me ironic that on the one hand you have people accepting science in those cases, but not wanting science when it comes to, for instance, polygraphs. So far as the law is concerned, there have already been some significant influences on the way law works and the way the trial system works. And I'd just like to touch on one or two of them, because I do think they have lessons for us. IT has resulted in a very significant increase in accessibility to law. In our common law system, much of our law, as I've mentioned, is developed by judges in giving decisions in judgments. 50 years ago, when I started as a barrister, even 30 years ago, many judgments of significance went unreported. They were either lost for good or very hard to find on a tape somewhere in the basement of the Royal Courts of Justice, and you had to know about the case in order to find it, and even then the tape was probably mangled. But now virtually every judgment that's given is available electronically, often on a well-known website, the Bailey website. So life has changed for lawyers, rather like it's changed for historians towards the end of the 15th century with the development of printing. We've moved from a shortage of judgments to an oversupply of judgments. Now almost every decision of the High Court and above is reported somewhere, and there's a wood and trees problem. In high-value cases, lawyers have to spend a lot of time, and hence a lot of clients' money, reading through judgments, only to conclude that they make no new law. But having spent their clients' money, the lawyers feel they have to justify that time by citing those cases in argument to the judge, even when they add nothing. But we do have, of course, not only the advantage of these reported cases, some of which are important and wouldn't have been reported, but we have various techniques of searching them quite quickly to see if they have points of relevance with the search function. Then there's the use of IT in trial systems, and particular remote hearings. From about 2010, remote hearings were very rare but occasional in very small procedural cases and so on. But with the advent of COVID, we suddenly found ourselves in a world where hearings were in fact, most hearings for those 2 years of COVID were in fact held electronically, were held on screen. and it was quickly discovered that they worked very well. I think, coming back to one point I mentioned, it was found that some people didn't like it because they didn't feel you could really assess a witness properly on screen. Not that I really understood that. More understandably, I think some people felt that they couldn't really have the feel of the court if the judge or judges were at the other end of a screen. Again, unless there's something about a sense of smell or some imperceptible feeling, it's hard to understand why, because you could see the judge is very clearly on the screen. Cameras in court is another example of a change. Until 2009, filming in court was illegal. It was a crime. Not even a judge could allow it because it was a statutory crime. But in 2009, when the Supreme Court was founded, it was decided that they would film every case. And now you can watch any case as it happens. You can order a cassette of the judgment. Maybe they've moved on, they'll send it to you down the line. And even recently, they started to film actual sentencing in significant cases of significant criminal cases. I mention that because it represents a very sharp change in perception as to what was acceptable. When you think about it, cameras in court are part of open justice. And as I mentioned earlier, judges sitting in open court and hearing cases in open court is central to open justice. But cameras in court were thought to be inappropriate. I think there are difficulties when there are witnesses who might play to the gallery, where there are juries who don't want to be seen. But in appeals where there are no witnesses, it seems to me, insofar as anybody wants to watch appeals, there is an unanswerable case for cameras. An interesting area where it sounds a little recherche, but where, in a way, the lawyer's function has slightly been taken over by artificial intelligence, albeit controlled by humans, is in relation to what's called disclosure or discovery of documents. In our system, unlike the civil law system, each party to litigation has to produce to the other party any document in its possession which is of any potential relevance. And in a complex commercial case, particularly with the advent of emails and the like, that means an enormous quantity of documentation. And it seemed to be becoming almost impossible to carry out a search for the documents. But with the development of search engines and search words, it has been possible to carry out the exercise which had previously been carried out by qualified lawyers of going through the documents to identify those which should be disclosed to the other side. And that is done by search words which, to be fair, at the moment, as far as I know, are not selected by AI, but are selected by the parties, or if they can't agree, by the judge, to see whether or not the words chosen are appropriate. In a sense, therefore, that is AI starting to impinge, it could be said, on at least the lawyer's function. But generally, as Richard Susskind has put it, we have been grafting new technology onto old working practices, but we are perhaps moving to what he has called more disruptive technologies. As AI generally and machine learning in particular develop and appear to be able to carry out increasingly sophisticated functions, the question has to be faced: to what extent will it be appropriate in principle and acceptable in practice to permit AI to replace lawyers in preparing and assessing cases and judges and juries in deciding cases? The extent to which it may be possible and the point at which it may be possible is not something which I can speak to any expertise on, but I have to say that everything that goes on in our brains, in my view at least, is either explicable electronically or electrically or chemically. And eventually one day it must be able to, I would have thought, be able to be mimicked. There may be so many different connections that it may require a new or several new generations of technology to achieve that end. But with quantum computers and so on, one wonders how far we are away from that. So we may have to wonder how far it will be acceptable. In terms of the potential for IT, there is evidence that artificial intelligence can predict the outcome of cases with a degree of reliability. In a 2016 paper, it was reported that AI predicted rightly the outcome of just under 80% of 584 European Human Rights Court cases. And the US Lex Machina case owners have claimed that their AI predicts the outcome of US patent cases more reliably than any human patent law expert. What one would be interested to see was the extent to which cases that involved judgment or discretion were accurately reported compared with those that involved sharp points of law or issues which may have been easy to detect. But the figures are interesting. And certainly in the US and China, in limited areas, there is use of IT and artificial intelligence to carry out some judicial functions. The fact that the judicial function involves the application of a value judgment and the exercise of discretion could be said to cut both ways. Undoubtedly, it renders it more difficult for AI to mimic a human judge. But on the other hand, it can be said that it would ensure that the personal foibles of an individual judge are removed. Benjamin Cardozo, a very famous US Supreme Court judge, said, "All their lives, forces which they do not recognize and cannot name, have been tugging at judges, inherent instincts, traditional beliefs, acquired convictions, and the resultant is an outlook on life, conception and social needs, which, when reasons are nicely balanced, must determine where choice shall fall." It could be argued that individual judges' subconscious biases should be a thing of the past. On the other hand, one of the main problems with AI, particularly in the light of human prejudices on the part of those responsible for the relevant machine, and in light of the use of proxies, is data and algorithmic bias. Indeed, that has been described, I think, as a touch point of vulnerability in the AI ecosystem. But over and above the question of value judgments and discretion, judging also involves, albeit to a limited extent, developing the law as well as establishing it. Whether AI is able to mimic the results of the human brain in this aspect is perhaps another matter. But sooner or later, it may have to be faced whether or not it's acceptable for court cases to be decided by AI, and indeed for legal advice to be given by AI. It seems to me that it might be possible, in some ways, easier for AI to judge a case than to give legal advice, because one of a lawyer's functions is to identify all the relevant issues and the relevant facts, which the client will not know, not being a lawyer. Whereas for a judge, ideally, it doesn't always happen, the lawyers will serve up the relevant facts and law and will have cut out most of the irrelevancies. But of course, judges deciding cases by reference to, or AI deciding cases by reference to what's served up to them is highly questionable. And of course, there's a problem with lack of diversity. Although, as I've said earlier, judges decide cases in different ways because they have different views. Are we going to get AI that has simply one view? Is it going to be monolithic? We all praise and value diversity, but it doesn't just come in the familiar sense. It also comes in diversity of outlook and diversity of outcome. And it does seem to me that if we have AI which has one answer to every question, and this point was made before, then we do lose a considerable amount of flexibility, a considerable amount of diversity, a considerable amount of colour. If, on the other hand, we have artificial intelligence systems which come out with different answers, then I suppose that you would end up with an AI machine which argues each party's case, a third AI machine which acts as a judge who decides who's right, and carrying this jeu d'esprit a little further, you'd have an appeal court with 3 machines, each of which no doubt is programmed to dissent from time to time. A fundamental objection to having issues decided by AI is that its algorithm involves unaccountable power because it's black box technology means that we don't know how a robot arrives at its conclusions. Even now, at the very early stage of AI, engineers sometimes struggle to understand the operation of their own systems. And the fact that most of the black box software will be valuable confidential intellectual property will also mean that the proprietor will be very unlikely to let anyone even try to investigate how it works. And this is the very antithesis of open justice, and would, at least if our present fundamental principles are to be maintained, mean that it would be unacceptable, both in principle and public acceptability, for AI to replace lawyers advising and representing clients, or judges in resolving cases and making orders. On one view, this is slightly ironic. We can have some go, in theory at least, at finding out how an AI machine makes its decision in some cases. We can't actually know what goes on in the human brain. 250 years ago, Lord Mansfield, possibly the greatest English Chief Justice, was asked for advice by an army officer who'd been appointed governor of an island in the West Indies, where he would have to administer justice. He had no experience, no legal qualifications. So he asked Lord Mansfield what he should do, and Lord Mansfield said, "Decide promptly, but never give any reasons. Your decisions will probably be right, but your reasons are sure to be wrong." And as I've mentioned, juries don't give reasons. So it might be said, with some force, that we shouldn't worry about black box reasoning. I have to say that that is said somewhat facetiously. Reasons, even if they are retrospectively worked out, are the basis on which our system works. A judge has to be accountable, has to explain themselves as to why they reached a decision, and parties have to know why they lost. It's often said the most important person in court is the party who loses, and that's the person to whom the judgment should be addressed. So they should know why they lost, and indeed it gives the Court of Appeal the opportunity to see why the judge reached the decision reached and whether the reasoning was right or not. If we can show that artificial intelligence reaches the right conclusion more frequently, faster and more cheaply than human judges, a superficially utilitarian view of justice would suggest that none of this should matter. Parties to litigation simply need an answer, and it should be the right answer, and the more reliable, the quicker and the cheaper, the better. Many politicians anxious to reduce expenditure on courts might be tempted by this argument, but I suggest that it would be the judicial policy equivalent of the Progress Party's defence policy in a Danish election in the 1970s. Its sole item of proposed expenditure was an answering machine to be installed in the Ministry of Defence with the message, "We surrender." Attractive though AI justice may be economically, at least so long as we remain committed to our fundamental idea of the rule of law in general, and open accountable justice in particular, the mere fact that a robot may one day tick all the outcome boxes better than a human judge will not do. At the moment, it seems pretty clear that public opinion will demand that humans, with their moral sense, experience, and emotional intelligence, as well as sometimes their faltering reasoning, in brief, their humanity, should be the ultimate arbiter of legal disputes. Although they give no reasons, the popular support for juries, as I say, tends to support this. A middle way, which receives much support in the literature, is a sort of partnership between a human judge and an AI judicial assistant. On the face of it, this would maintain a human judge ultimately making and explaining the court's decision, while the decision-making would benefit from the advantages of AI. It's superficially attractive, but I wonder whether, at least arguably, it's the worst of both worlds, at least if it means AI getting involved in the actual decision-making. In other words, giving the conclusion it has reached on the case to the judge. Apart from the problem that open justice would require that all communications between the judge and the machine would have to be shared with the parties, and the parties should have the opportunity to comment on it. Otherwise, there'd be no open justice. There is the problem about what is the human judge to do with the AI's decision or advice. They have a conclusion on this basis with no reasoning. If they follow it, they might as well not be there, and if they don't follow it, they're probably wrong. Further thought suggests, and I conclude with this, that the whole problem may at least to some extent be academic. If and when, and to the extent that AI can be relied on to produce reliable, quick and cheap outcomes, it will presumably be available on the market. In those circumstances, potential litigants would presumably simply agree to put their dispute to the AI adjudicator and get the answer without recourse to the courts. So judicial AI may not simply represent a great change to litigation, it may mean the end of litigation. Admittedly, an extreme possibility on which to end. Thank you.
Thank you. A strong set of suggestions and ideas for us to get our teeth into. Aislinn.
Thank you, Jeremias. It's clear from what Lord Neuberger has said that technology has already had many impacts on the justice system. And it seems to me that it also has much more to offer. For example, if AI tools which can reliably predict litigation success become freely or cheaply available, that would improve access to justice, because parties could identify whether their claim is worth pursuing without recourse to expensive lawyers. Lord Neuberger mentioned evidence about the high success rate of predictive AI for decisions by the Strasbourg Court. And in this respect, it might be that the oversupply of cases has an upside in the form of adequate training data. Andrew mentioned earlier the idea that AI is sort of like a collectively written book. And that reminded me quite of what case law is like, because common law is also like a collectively produced corpus in the way that Grant described earlier. But if an algorithm can accurately predict the outcome of a case, one might legitimately ask why it cannot also decide it. And as Lord Neuberger points out, this is where matters become more complicated. It may well be that algorithmic justice will become a form of alternative dispute resolution to rival other private resolution systems like arbitration. But it seems unlikely, to me at least, that recourse to such technological justice would be so great as to entirely extinguish the public courts. So I think the question still arises as to what our courts should offer. Should human judges be retained? One issue which the wholesale replacement of human judges raises is the black box problem, which Lord Neuberger has identified. And it does seem difficult to conceive of a system of open justice in which cases are decided by opaque machine learning algorithms. But having said that, work on explainable AI seems to be progressing at a rapid pace. So work by our colleagues at Oxford, Sandra Wachter, Brent Mittelstadt and Chris Russell, for example, has identified the possibility of counterfactual explanations, which would give a decision followed by a statement of how the world would have to be slightly different for a different decision to occur. That kind of reasoning might still not be enough in the justice context. Professor Jeremias has pointed out in writing that AI explanations may never be sufficient, particularly if the tool can't justify its decisions in the way that we understand that as humans. But I think the question of whether AI can ever produce an adequate explanation is at least partly a technical question, so I'll park that for now. Let's explain then that the algorithmic system does produce outputs which are not only accurate as a matter of law, but are also explained. Should we then use them to decide cases? I've already mentioned the positive access to justice implications of having litigation predictors, and Lord Neuberger also noted that an essential feature of the rule of law is that every citizen should be able to find out what the law says on an issue. I think it's an element of that. But the corollary of that statement is that the law should be both clear and consistently applied. Indeed, in his work on the rule of law, Lord Bingham identified that it requires both that the law is accessible, intelligent, clear and predictable, and that questions of legal right and liability should ordinarily be resolved by application of the law and not the exercise of discretion. Lorraine also touched on this point earlier when she said that what citizens have to expect from the law is not justice but predictability. It's worth noting that although debate rages on what the content of the rule of law is, the need for clarity and consistency of rules is broadly accepted, even by those who advocate for a thinner conception of the rule of law than Lord Bingham did. So it's possible that algorithmic justice would be more consistent justice, because an algorithm can be constrained to provide the same answer to the same case. The same cannot be said of judges. A 2011 study in the US found that judges making parole decisions issued more favourable rulings to defendants after their lunch break than before. And I think few of us would want questions about our liberty to be affected by whether someone's had lunch yet. Cass Sunstein and others have also documented various similarly egregious examples in their work on noise, which has been mentioned earlier. For example, in asylum cases, differences between the rates at which judges grant asylum. And it shouldn't really be any surprise that different judges will apply their discretion in different ways. Indeed, it's not uncommon for advocates to tailor their submissions to what they perceive to be the desires of a known judge. And even technology has made this task easier, because legal databases now allow us to search for judgments by the judge's name. So AI judges could actually enhance the rule of law. That's not to say that AI-generated decisions will be free of all the infelicities that plague human judgment. I've written in the past on the ways in which automated decision-making systems can breach equality law, and Jeremias and I, with our colleague Ruben Binns, have pointed out that algorithms can effectively replicate human implicit biases. It's questionable whether that would ever be resolved. And it's also notable that algorithmic decision-making is still in many ways arbitrary, and that's a reality that's all too obvious for workers whose managers have been automated, which is an issue Jeremias is doing in-depth research into. But let's just say that the utopia algorithm could be designed. That is to say, a neutral algorithm which accurately applies the law, even in new situations. In that case, it does seem that questions of the rule of law can cut both ways. Challenges do still remain. Professor Tassioulas has raised several concerns about automating judging, one of which is the answerability of the decision maker. And that's more than a question of mere legal liability. The point is that human judges take moral responsibility for their decisions, and that might operate as a source of some comfort to a disappointed litigant. Lord Neuberger has also touched on this point when he mentioned the importance of a thought-through judgment to the losing party. Michael Livermore at the University of Virginia suggests that being able to make arguments in a case and have them considered is a participatory right, which would inevitably be lost were judges replaced with machines. So perhaps we shouldn't be too hasty with dispensing with the procedural aspects of human justice and depriving litigants of their day in court. But there might still be an attractive middle road in which AI could act as a check on the bounds of judicial discretion. It might well be that this will be the worst of all worlds, and I don't have time to go into issues like automation bias, which would affect human judges taking AI recommendations. But an algorithmic system could be made available to judges to check the likelihood that another judge would reach the same conclusion, just so that they can make sure they've thought through why and explained it. Given the need for the clarity and consistency in application of the law, it still seems to me at least that there may be some room for useful deployment of AI in the justice context.
Thank you, Aislinn. At least when it comes to the prediction of judicial behavior, some jurisdictions have taken pretty extreme approaches to this. In France, it's a criminal offense to try and use software to predict the behavior of a judge. When I pointed this out at a recent judicial training, I could sort of see mentally people already composing emails to the MOJ to get similar legislation through in the UK. But so far, we haven't seen that yet. Sandy, over to you.
Okay, well, thanks. So I'd like to address the main question raised in David's talk, which I take to be, to what extent will it be appropriate in principle and acceptable in practice to permit AI to replace lawyers in preparing and assessing cases, and judges and juries in deciding cases? So I'm going to focus on judges. So in thinking about this question, I think it's helpful to distinguish between two things. Firstly, there are values which can be realized by both human and AI judges. For instance, if the legal rules being applied are morally justified, then there's a value in those rules being correctly applied. And it seemed uncontroversial, based on my extremely limited and superficial knowledge of AI, that AI can be trained to correctly apply rules. And in some contexts, they may be more likely, for reasons that Aislinn mentioned, that they may be more likely to apply them correctly than their human counterparts. So we can call these mutually realizable values, values that can be realized by both human and AI judges. Second, there are arguably values which are uniquely realizable by human judges. David suggests in his lecture that AI judges, at least as they are likely to be developed, cannot realise a fundamental aspect of the rule of law. He mentioned that the requirement of open justice, and that unless AI is developed so that it can demonstrably think, feel and reason like human beings, that a system with AI judges will fall far short of a fundamental dimension of accountable justice. So whether it's appropriate in principle then to permit or require AI replacement of human judges depends then on a comparison of the relative effectiveness of human versus AI judges in relation to values which can be mutually realised, and secondly on whether there are any values that are uniquely realisable by human judges, and theoretically I suppose on whether there are any values that are uniquely realisable by AI judges. So let me make two observations about this relatively simple distinction. So first of all, it might be tempting to think that judgments of comparative effectiveness or comparative efficiency in realising values are somehow necessarily consequentialist in character, and for that reason to right-minded non-consequentialists, less important than the issue of whether there are any values that are uniquely realisable by human judges. But clearly that would be a mistake. If we have a set of legal rules that are believed to be just, and AI is much more likely to consistently apply those rules correctly, then there's a powerful argument based in justice for requiring, not merely permitting, the use of AI judges. So non-consequentialist views of justice might strongly support the adoption of AI based on its comparative efficiency at realising justice, not because maximising just outcomes is the order of business, but because respect for justice requires us to realise it effectively. The second observation is that even if AI judges are much more effective in relation to mutually realisable values, it may be that there is an important value or set of values that can only be realised by human judges, and it may be that that value has a priority of some kind or a limited priority over the gains in comparative effectiveness. It depends, of course, on the nature of the value in question. So I was intrigued by David's suggestion that the value that's uniquely realisable by human judges is some dimension of the rule of law, and I want to spend the remainder of this comment dwelling on this. So why are AI judges unable to fulfill a fundamental aspect of the rule of law? I think there's four things in David's lecture which are raised as problems here. So one is public reason giving. Another is the substantive acceptability of reasons if they were given. Thirdly is an ability to feel. And fourthly, a notion of accountability. I'm probably only going to be able to, within the time I have, to speak about the first three, and even then rather speculatively and superficially. So on the first, public reason giving, I agree, of course, that if this weren't a feature of AI judges, then this would be a serious strike against AI judges. Reason giving matters even when the outcome imposed is a morally justified one. But it wasn't clear to me, based again on my superficial knowledge of the prospects of AI, that there's some in-principle barrier to public reason giving being built into AI judges. If AI can be trained to appropriately identify reasons for decisions, if it can be trained, for instance, to identify the salient facts that were considered to justify a past decision, and based on many cases to ascertain the relative weighting given to those reasons, why can't it additionally then express those reasons? What about the claim that if reason giving were a feature, the reasons given are unlikely to be acceptable? So I can think of two reasons why this might be the case. One is that AI arrives at the morally correct outcomes, but the reasons for these don't cohere with popular or conventional morality, and are in that sense unacceptable. Another is that AI simply doesn't provide plausible moral reasons for its decisions. But again, why believe that this is more likely to be the case than the opposite outcome, that the reasons given are broadly acceptable in either sense? So one argument might be that moral reasoning is necessary for cases in which the law is indeterminate, and morality is, on the one hand, indeterminate on certain matters, and on the other, even if determinate, profoundly complex, and so not capable of being learned by an AI machine. So if morality, like law, runs out on certain issues and is in that sense indeterminate, it's not obvious why human judgment is necessary to resolve the indeterminacy, at least in the kinds of interstitial case that judges ought to be dealing with. Human judgment by hypothesis is not going to better track the correct decision in these situations. I find more plausible the idea that morality is profoundly complex. Even non-consequentialist theories of morality which aim to identify a basic underlying principle for moral rightness, such as contractualism, allow for the structured balancing of various moral principles. Whether a principle is reasonably rejectable depends upon a variety of moral variables. or deciding whether some particular action is consistent with a being's dignity is not something that can be read off past decisions about whether an action is consistent with dignity, and nor is it merely an arbitrary choice. Even here, however, I'm open to persuasion. There are always facts in virtue of which something counts as contrary to a person's dignity or a principle is reasonably rejectable. And although there are many morally relevant variables, it doesn't seem like they are impossibly numerous to be the subject of complex rules and principles. If anyone has read the works of Francis Cam, they might be quite persuaded by the idea that morality could be reduced to extremely complex principles and rules. If there is a real barrier here, it seems more likely to me to lie in the fact that moral intuition plays a crucial role in understanding how to deal with balancing between moral principles and considerations. And AI, so far as I know, doesn't have moral intuitions. The final point I'll comment on is the lack of AI's ability to feel, which David also mentioned, or the ability to have emotions. Is there a moral requirement, or is it morally desirable that judges are able to feel? Although the hard-nosed property lawyers of the Chancery Bar are not well known to be overbrimming with sympathy, it is arguably still the case that they are able to feel, or once were. David does make the point that AI might learn to mimic the trappings of human sympathy. One question this raises is whether mimicry is enough. Even if my supposed friend could perfectly mimic the trappings of sympathy, but was not actually sympathetic, things would still not be entirely ideal. Sometimes, of course, emotions lead people morally astray, but arguably there's a limited but valuable instrumental role for emotions in keeping people morally on track. Whether there's a constitutive role for emotions or a role for emotions in acquiring moral knowledge is something on which I'd be interested to hear people's views. Thank you.
Thank you, Sandy, and thank you to all the panelists for keeping very nicely to time. David, would you like to have a few minutes before we open up to Q&A to engage with some points that Aislinn and Sandy have raised?
Yeah, I thought they both made very, very good points, very interestingly. 2 points occurred to me in relation to each, and one more generally. Aislinn's development of the idea of people testing their case with AI before they went to court has a certain resonance. In this country about 25 years ago, the idea of mediation, banging people's heads together, as it were, before they went to court, started to become quite fashionable. And the courts became very keen on encouraging parties to mediate before they went to court with a view to try to settle. And I suppose one possibility is that the rules develop, if AI becomes capable, of requiring parties to submit their case to AI before going to court. If they choose to go to court after the AI has told them they're going to lose, that's their lookout, but it may make them think again. The second point I had in mind was that this idea of checking a decision of a judge or an AI machine is something that has happened in China, as I understand it. The Chinese have a system where they record all judgments in smaller cases. And if a judgment comes up from a judge which doesn't seem to fit in with all the previous decisions in the area, the machine automatically generates an appeal to a higher court to consider that decision which appears out of line. So far as Sandy is concerned, I think that much of what he says I don't disagree with. I think that we're all at the moment arguing about or talking about AI having a judicial function without knowing or exactly what the AI is going to do. Is it able to decide across the piece? Is it able to give reasons which are comprehensible? Is it able to give reasons which are generally acceptable? If it were to tick all the boxes, then it would be rather more difficult, it seems to me, to object to it deciding a case. But whether that would be publicly acceptable in the end must be the acid test. If judges are not divorced from the public, we have to take into account public view to an extent. We don't go with all sort of every trend that happens. But in the end, the rule of law involves the courts having the confidence of the people. And if the court's view of life is completely divorced from the generally acceptable view, then the rule of law is under threat. And if artificial intelligence judges, however well qualified, are not acceptable to the public, then that is rather that. I think that what we may get to, and it's not a point I dealt with, but it occurred to me as I was listening to Aislinn and Sandy, was it may be that there are some aspects of the law, some decision-making, where a machine is better than a human being, and there may be other areas where a human being is better or more trusted than a machine. And there's nothing to stop, in theory anyway, and I'd have thought in practice, saying this part of the case can be decided by a machine and this part by a judge, a human judge. Finally, having been a chancery practitioner and a chancery judge, in my defense, I should say that some, at least chancery practitioners, are quite human. Even some judges. When I was initially in practice as a judge, as a barrister, there was no retirement age for some judges who'd been appointed before 1959. They could carry on until they died. And I have to admit that one or two appeared to carry on afterwards. Thank you.
Thank you very much indeed, David. And I think there's a lot of truth, particularly in that last point, and actually in the sort of question of the digitalization of the justice system, it is going to be very context specific. And I think that also fits with our broad understanding of the rule of law. When we look at things like questions of systemic judicial review, for example, this realization that actually both the risk of futility and the cost of futility are really important functions in deciding when the rule of law is engaged and when not will come in here. If it's a parking ticket adjudication, I would argue that the risk of futility of it going wrong is very low. That's something that actually automated systems can learn and do very well. And the risk of it going wrong, the cost of that futility, actually is very low. It's going to be £25, £50. If, on the other hand, you've got a very complex dispute where lots of difficult facts are at stake and potentially someone is going to jail, that will be the other end of the extreme where I think the rule of law, at least as interpreted in common law jurisdictions, will for a very long time stand against the automation of decision-making. We've got plenty of time for some questions, so if the black magic box appears somewhere from behind, there it is. If you could also maybe just briefly introduce yourself just with one sentence and give us a background, who you are and where you're based. I can see one first arm up there.
First one, I get the Commons football. I'm Philip Corliss. I'm in the Faculty of Philosophy here. I'm really interested in this idea of reason giving, which clearly seems really central to the law. And I'm also really interested in the extent to which AI technologies can maybe raise questions kind of for us, about us, right, rather than just sort of kind of practical questions of how to deploy the technology. And I'm wondering, in the context of reason giving, whether the possibility of having AI decision making as a black box maybe sharpens questions about us and the grain of reason giving, right? So if I think about it purely grammatically, I could say, okay, well, here's my reason. The computer says no, right? I can phrase that in the kind of grammar of reason giving, but that's too shallow. And then I say, okay, this doesn't really qualify. And then I could say, hey, okay, well, maybe let's give reasons that would be sort of compelling or at least cogent for whoever the judgment went against. That was an example that came up. Okay, well, what if the judgment went against a skeptical philosopher? Well, good luck there. You're never going to get enough sort of justificatory reasons to kind of make it seem like you're settling any questions there. But obviously that's the other extreme that certainly in legal practice you'd never demand. I'm sort of wondering if, with AI technology, you have the possibility of something that is, in a sense, an extensionally competent judge that might sort cases correctly, but without giving reasons, okay? So now we have a case where we can't just say we need to give reasons because that's what's absolutely necessary to have a system that correctly classifies things. Well, now, what's a reason for demanding reasons, and at what grain should we demand them, right? So what maybe we kind of need a theory now that tells us what the appropriate grain is and for what reason we would demand that. So I'd be curious if what the panel thinks about that, the grain of reasons.
I think anyone who's acted as a lawyer, if I get the point, will know that when you lose a case, and even I lost cases, your client wants to know why. Why did I lose? And I think you do need reasons from the judge to know why you lost. And if you're going to have an appeal system, you need to have an appeal system. And in a system which develops the law through cases, which like ours does, you need to have the ability to develop the law in that way. Now, it's fair to say that in France, I believe, the Cour de Cassation, the top court there, tends to give unreasoned decisions. The decisions are then explained by academics, and the academics' explanation becomes the law. Now, that's probably a gross exaggeration or oversimplification, but even if it's right, it doesn't alter the fact that reasons, even if not given by the court, are needed in order to understand decisions and in order for the law to develop. Sometimes reasons involve actually ultimately, although they're dressed up, saying, because I say so. I mean, I referred briefly to interpretation of contracts. You have a sentence in a contract and there's an argument about whether it means X or Y. Judges, including me, I regret to say, have prosed on for pages about the principles that to be applied, etc., etc. But underneath it all, we're really saying, this is what I think it means. And in a way, the impression that you have as to what words mean is not capable of great elaboration. Similarly, many cases involve contradictory principles, particularly if you go to the Supreme Court, it will be a difficult case, and often there'll be two conflicting principles. And in the end, the judge will say, I prefer this principle applying overriding the other principle in this case, or generally. But in the end, it's a value judgment. But nonetheless, you do try and give reasons and explain how you arrived at it. And I do think it's what the losing party expects, what the system expects, and what an appeal system expects. I'm not sure it's an answer to your question. If it isn't, I apologize.
I take it the question is, how do you specify the granularity of the reason? So there's a requirement to give reasons. At what level of granularity does one have to give reasons to satisfy that requirement? So it depends on the rationale of the requirement. So if the rationale is accountability, that we want to make the decision subject to review by some other decision maker, then the reasons have to be described at a sufficient level of granularity to be able to assess, has this person made the substantively correct decision? So computer says no is not going to allow you to assess, did this person reach the correct decision on the balance of reasons? Sometimes people describe the requirement as based on a sort of respect for the person who's the subject of the decision, that it's a sort of respect for another person's rationality requires you to give reasons for the decision. Not sure about that and what that would entail for granularity. It's quite a vague idea. But a colleague of ours at Balliol, Hassan Dinger, has argued that when you are subject to an adverse decision, you've got an interest in making sense of your life, and that if you get some adverse decision, in order to make sense of what's happened to you, and the normative status of your life, if you're accused of some terrible wrong, in order to make sense of your life, you have an interest in knowing the reasons behind that decision, and that perhaps that also has some implications for what level of granularity, what would allow you to be able to make sense of this decision and set it in the context of your life narrative.
Hi, I'm Dr. Natalie Barham. I'm Director of Research at the Legal Education Foundation, and I was formerly advisor to the Court Service on open data policy. So thank you very much for the really thought-provoking presentations. I had two questions for the panel. So firstly, the sort of policy interest in the application of AI to the justice system is disproportionately focused at the moment on low value, high volume areas of law, where the litigants involved are disproportionately people on low incomes or members of groups who we already know have lower levels of trust and confidence in the existing justice system. Given that the justice system and our democracy rests on public consent, what are the mechanisms, if we are looking to deploy these solutions into the legal system in the future, what are the mechanisms that we need to build in to ensure that the public are effectively involved and consulted in the way in which these systems are deployed in order to ensure that we maintain public trust and confidence? So that's one. What are the mechanisms that we need to build in to take the public with us in these debates? The second question that I had, there was lots of talk in the presentations about the potential access to justice benefits of AI in the context of predicting the outcomes of legal cases and helping people to make decisions about whether and when to come to court. There are also huge access to justice challenges that are created by the way the data landscape in relation to the legal system is structured at present. The volumes of data that are needed to develop these solutions are disproportionately held either behind paywalls or by repeat players. So the question for the panel is, when we're thinking about who develops these systems as well as how, whose responsibility should it be to develop predictive tools, and how can we ensure that those developing those tools, that in developing those tools we don't exacerbate rather than address existing access to justice challenges? Thank you very much.
Who would like to start us on that?
I'll start, yeah. Yeah, two really interesting points. And I think everything we've said, at least everything I've said on this panel, is quite pie in the sky in the sense that there are two big kind of elephants in the room. The first is the state of the technology. I think that we're far from the type of algorithm that I described, and I don't think it would be safe to deploy, certainly in a judicial capacity, given what we've seen with the Compass algorithm in the US, and probably also in a litigation advice context, these kind of algorithms at all yet. And secondly, the state of the justice system as it is. I worked some years ago for the Charity Justice on the reform programme, and it was quite shocking to see the rate at which the courts were closing and the rate at which advice deserts were expanding. So I think that those two challenges absolutely remain and would need to be examined before we could think about rolling out one of these systems. So as to the access to justice challenges, I think that the move towards the increased use of bail is great, but absolutely if these litigation predictors were developed by private companies, as seems most likely at the moment, it doesn't really seem that they would be in the public forum. So absolutely I don't want to be seen as advocating for a kind of a blind move towards this situation, more just wanted to look at what the ethical issues would be if that were to happen. But I'll turn over to the others.
My experience, and to be fair, it's some time ago, but I was, to my children's intense amusement, judge in charge of IT. At that time, I have to say that my experience of government commissioning of IT and running of IT systems was not impressive. And my worry is that if the government were to develop, or the MOJ was to try and develop a system, they would try and do it on the cheap, and it would not work. If it was possible to do it properly, then it obviously should be done. But if there isn't the money, better not to do it at all than to do it on a half-baked basis. I think it's very likely that if it proves financially worthwhile, companies might develop systems. But unless it's quite cheap, one of the problems with law, unlike medicine, is that if you develop a system for detecting tumours, you can apply it to 8 billion people across the world. If you develop a legal system that applies in the UK, it only applies to 60 million people. Well, that's a lot of people. If it's a very sophisticated machine, it's quite difficult to justify. So there may be an economic problem. The government won't spend the money, and it won't be worth doing it privately. And as I say, better have no AI system than a second-rate, let alone worse one. So far as public involvement is concerned, it very much ties in with the chair, with Jeremias' comment about lower value cases and with less serious outcomes. I think in terms of the public interest, it's always quite difficult to get the public that concerned about legal questions or to do with the rule of law until they actually become involved. But I would have thought it would be worth finding out what the satisfaction rate among people who are subject to AI decisions is. I would have thought it would be worth, possibly, ideally if it can be done properly, actually, which often is not done, having a test of sort of a control test so that you've got human judges and AI judges judging the same case, each not knowing about the other. Well, obviously the AI won't know about the human judge, but the human judge would know about the AI judge or what it decides, and seeing what the correlation is in terms of decision making. If it's 100%, then the future of human judging is rather at risk, but at least you'd see how reliable the AI judge was.
Well, on a purely economic perspective, of course, one question is that something like arbitration might be one of the first areas where there is the incentive, given the cost of an arbitration, the fact that people are already willing to take their claim out of the legal system, and the fact that, you know, it's sophisticated parties on both sides usually.
Yes, I'm not sure the lawyers involved would agree, but I see the point.
Or indeed the retired justices
Arbitrators.
who sit as arbitrators. I've got next.
Thank you. Thank you so much. I wanted to ask about the panel's thoughts on a different reason that we might not want AI as judge. David had spoken about the law developing even as a result of wrongly decided cases, but for an AI, there's no such thing as a wrongly decided case because everything that's been trained on is backward looking. So it seems that there would, under an AI judge, never be the possibility for landmark cases that really change along with the development of culture. So I'm American, I'm thinking about things like loving v. Virginia, right? So now we can have interracial marriages that are legal. So I would be very interested to hear from the panel on this topic.
Well, I don't know, in a sense that should be for Sandy, because it ties in with the point he was making. If AI could be developed so that it could take into account that sort of factor, then that would be fine. But if it couldn't, then it would be a problem with AI. I think it's until AI could take into account changes in society which should be reflected in the law, then if AI could do everything except that, then I suppose you could invent a system whereby AI decides the case, but if a party who loses says, I've lost on a ground where the law should be changed, then that party could take it to a human judge. That's how it might work, but I don't know.
Well, yeah, I mean, I agree essentially. I think it's a very pie in the sky answer, but I suppose it really does. That depends on how the AI is trained. I mean, if it's trained with a very abstract moral principle, you know, if the AI was a simple utilitarian, it could easily respond to new facts because it might learn new causal facts about the world and therefore decide, well, now something else maximizes utility. But even if it's trained with non-consequentialist principles, those principles could also be responsive to new causal facts or learning new causal facts. So I think it's in principle possible for non-consequentialist framing of algorithms even to respond to changes in non-normative facts, which the machine learns.
Just to add one thing to that, I think there's also the point that cases like Loving are appellate cases. Lower courts can't depart ordinarily from established precedent. And I think it somewhat ties into what Natalie was saying as well about the perhaps disproportionate focus on kind of low value claims, in part because those are the claims that most routinely come before first instance courts. So I think when we're talking about these kind of systems that will learn from previous cases, I personally don't think we can really be talking about them at an appellate level because the opportunity to develop the law still, I think, has to exist. And my personal view is I don't think that could be devolved to an algorithm.
In the interest of time, I think we might do questions in clusters. So if we could ask people to ask their questions very quickly. I've got one group of 3 questions down here, or 4 questions down here. Are you happy to take them as a batch? I think that might help us get through more questions.
Thank you. My question is about the nature of the law itself and what the consequences of AI moving into this area would be for its relationship to sovereignty, not just in terms of work and employment, but in its relationship to sovereignty itself.
Question in relation to the AI judge. Now, one of the things about the relationship between citizens and judges is that we're all part of the same political community. And it's difficult to see how an AI judge, how that could be the case for an AI judge. And one aspect of that is that to the extent that a judgment, particularly a judgment that develops the law, affects the political community as a whole, the judge themselves have to live with the consequences of that along with the rest of us. So, for instance, if there is a judgment which potentially involves accepting an increased risk to national security in the interests of protecting civil liberties, well, to the extent that there's a risk, the judge bears that just as much as the rest of us do. We're all in that together. And that aspect of judges and citizens being part of a common project and a common political community seems to me to have something of importance when one's considering what makes the judge's role legitimate. And I simply don't see how you would replicate that with the AI judge.
Thank you. And then if you want to pass it right down to that row, and then we'll go down here.
My question is that if we suppose, for the interests of access to justice, that any AI machine placed in an adjudicative capacity were not wrapped behind confidentiality, might that then bring into prominence the sort of reasons, the sort of input reasons that we previously didn't and couldn't feasibly examine in the human contexts? For instance, the disposition of a judge before and after lunch, since these kind of input reasons in the AI context may be more easily identifiable mathematically and scientifically.
Thank you.
I think one of the things we've been doing all day is trying to figure out what is specifically human about the act of human judgment. In the previous session on medical imaging, clinical judgment involved a lot of pattern recognition. When I look at an X-ray, I look at 200 X-rays, and over time I recognize pattern. By analogy in the law, a lot of legal judgment, the act of judgment, is pattern recognition. That is, this looks like a similar case, this, etc. And you can see there that if legal judgment is about pattern recognition, then you can see how AI could help, because that's what AI is terribly good at, is pattern recognition of various kinds. But how can AI deal with the other aspect of human judgment in the law, which is trust? I mean, presumably, I'm not a judge, so I don't know what you guys do, but my assumption is that at a certain point, lawyers and judges are crucially involved in one of the most excruciating aspects of human judgment, which is, do I trust this witness? So assessments of veracity are often the most difficult things that human beings ever have to do. They're a judgment call if there ever was one. And I'm very unclear as to how AI would help you establish veracity and how you would use AI to establish trust in testimony.
Thank you. I think 4 questions, quite distinct, but actually with some very clear common themes about the question of humanity and the relations implications. David, would you like to start?
On the first point on sovereignty, I'm not sure whether it's human sovereignty or national sovereignty. On national sovereignty, I think AI has no bearing unless we have, as it were, foreign AI which may be based on other law or other practice or other experience, and we don't know what goes into it. It becomes a bit like national security. On human sovereignty, I think there is a serious concern that AI, depending on its accountability, depending on how we can see how it works, that is a fair point. I think the point about citizens and judges and the fact that judges take the consequences of their own decisions in a way that non-humans don't is entirely true. But I think in practice it would apply in the judge's thinking. It shouldn't apply at all, in the sense that you shouldn't be thinking, how would it apply to me? But nonetheless, in terms of principle, it's a good point. I would have thought it wouldn't apply even in principle in that many cases, but as a sort of fundamental philosophical point, I think it's unanswerable. So far as confidentiality is concerned, or knowing what goes on, it's quite difficult because, as I say, a judge gives reasons, but behind the reasons may lie the real subconscious reasons, and behind the reasons also lie subconscious biases. And you can sometimes, when you see a judge, have a pretty good idea of what some of those biases are. You won't know others. With a machine, again, it comes back to what you know about the machine. But in practice, it may be easier to work out, not least because machines' decisions may be more consistent, or because you may be able to get more decisions from machines, or because you may have sufficient information about how it's programmed. That's entirely true. So far as the final point on assessing witnesses is concerned, it's a very interesting point. I'm very dubious about my ability as an individual to see whether somebody is telling the truth. I remember early on in my career as a judge, I was listening to a witness who objectively, his evidence didn't seem terribly reliable, but I found myself wanting to believe him. And I suddenly thought, in a moment of self-knowledge, I suppose, why am I doing this? And I realized that he reminded me of my father, who just died. And it was quite a frightening experience in the sense that I thought, this is what goes on in your subconscious. It's factors like that that influence you. And I think, to my mind, any self-respecting judge will put out of his mind or her mind, as far as they can, things like the impression the witness makes. Whether they give their evidence in clear terms or in halting terms, whether they shuffle around, whether they're hesitant, and so on. And in most cases, particularly of any complexity, you've got a lot of contemporary documentation. Much more reliable to see whose evidence is consistent with that, much more reliable to see whose evidence is inherently more likely, whose evidence is inherently inconsistent, whose evidence accords with other witnesses' evidence. Occasionally, and this is the wretched thing that juries have to do, you've got nothing other than the impression the witness makes. But it is a very, very unreliable piece of way of judging cases. And whenever I heard myself in a judgment saying, appeared a very reliable witness in the witness box, I thought, you're at the bottom of the barrel. And the evidence that's been accumulated on this is very depressing in terms of the reliability of judges in assessing the reliability of witnesses. And Lord Legate, as he now is, but he, in the Supreme Court, but he's given some very good judgments in the Court of Appeal in first instance about the unreliability of witnesses and the unreliability of relying on the impression they make and the way they give their evidence. So I'm not sure about that, but it's a very interesting point.
Aislinn and Sandy, any concluding comments from the two of you?
I can make a comment about the political community point, which is very interesting. I think I find that persuasive, although I wonder why is it that we think that matters, that being a member of the same political community matters to the legitimacy of the judgment. You know, if you have a purely instrumentalist account of that you think, well, being part of the same community matters because, you know, if you have to bear the consequences, then you might, you know, think more carefully about the decision. If it's a purely instrumental thing like that, then, you know, we shouldn't really worry about it in the context, or we should worry about it, but it seems in principle possible to meet the concern if it's just a purely instrumentalist one, but does being part of the same community have some non-instrumentalist significance? I'm not sure. It seems like it does, but...
A final concluding comment, I suppose, would be that there may well be very good applications for AI in the justice system, but I think first we have to invent the good AI.
And on that happy note, thank you very much indeed, David, Aislinn, and Sandy for joining us. So you can join them.